You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Florida Supreme Court is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Kaylor versus the state of Florida.
May it please the court, Your Honor, my name is Dave Davis, representing Mr. Matthew Kaylor in this capital case. Mr. Kaylor was charged with and convicted of first-degree murder, sexual battery, and aggravated child abuse, arising out of an incident that occurred in July 2008 in Panama City. In June 2008, Mr. Kaylor came from Georgia, where he was on felony sexual offender probation, came down to Panama City, took up residence at a Value Lodge motel. It's sort of one of those extended stay, sounded like an extended stay motel, and had some cocaine and was selling it. By July 8th, apparently his cocaine had been stolen from him, so he was very frustrated. Well, on July 8th, a 13-year-old girl named, which I'll refer to as MH, knocked on his door asking for a cigarette. She came inside the motel room, and within minutes they were having sex. After they'd had sex, Kaylor, according to his statement, snapped and then strangled the girl. He then, after he strangled her manually, then took a telephone cord and also strangled her, and then pushed the body with her clothes underneath the bed and left, and was arrested some couple days later, at which point he glad to see the police and confessed to the murder. Like I say, the state charged him with first-degree murder. One of the underlying felonies they charged him with was aggravated child abuse. Before trial, defense counsel moved to have this aggravated child abuse dismissed because under this court's ruling in Brooks, the aggravated child abuse merged with the murder and therefore was not an offense.
What was the which acts were basis for the aggravated child?
The state attorney relied primarily on the strangulation as being the acts leading up to.
Primarily.
Well, I think he was also he included the sexual battery as also being torturous and as being torturous and also becoming because it was torturous, therefore part of this aggravated child abuse as well.
Isn't that then already distinguishable from Brooks?
No.
Well, let me finish
sorry.
my question. Okay. In that there was not a single act, several district courts for us that said, but in cases where there have been multiple acts that form the basis, in this case, both for the sexual battery as well as for the murder, why isn't Brooks limited to a situation where there's just a single act? Well, especially in this case.
Well, they charged aggravated. I'm sorry. Maybe I'll back up here. They charged aggravated child abuse, and that was strangulation. And they said that the strangulation form was the aggravated child abuse.
Were there multiple acts of strangulation itself? Was there manual strangulation and strangulation with this cord,
yes.
Telephone cord?
Yes, but the state never made that distinction. By way, when they charged in the indictment, what they charged was they charged him with felony murder or strangulation. Does
the state necessarily have to say, and strangulation by manual strangulation and strangulation with a cord?
Well, what I'm saying, it doesn't really matter because it was all single conduct, and that's what we're looking under the felony under this merger doctrine. It's not single stab wounds, which were, for example, in Brooks. You're looking at the entire conduct that formed the aggravated child abuse, and here it's just not because the whole purpose of the merger doctrine is to require as the legislature requires the state to prove murder. How? Primarily, they want them to prove by premeditation, a fully formed conscious intent to kill. When you allow them to prove it by aggravated child abuse, and all they have to do is show an intent to cause great bodily harm, you're in essence letting
Was
the state...
there premeditated murder in this case?
Well, they charged him by premeditation as well as felony murder.
And,
Now,
and was a general verdict for
yes,
him?
it was a general verdict. And so, I'm sorry, I'm kind of getting over, I don't want to overrun you like I'm doing with Justice Periente, but the idea behind the merger rule is because aggravated battery is a special form of felony in the sense that oftentimes that felony merges the acts which are become the aggravated battery merge with the underlying with the murder, then it's the merger doctrine precludes the state from proving felony murder by aggravated battery
But
or
the
lesser
merger
intent.
doctrine is a doctrine of legislative intent. It's not a doctrine of constitutional magnitude. Do you agree with that?
That's correct.
And you're not making a constitutional
No.
issue. We've had cases where the idea
Right.
that there's an automatic aggravator that could make the death penalty unconstitutional, that's not in front of us in this case.
No, and in fact, that as it turns out, I represent Brooks in the Brooks case, but I clearly recognized in Brooks as well, and the court recognized in Brooks that this involves a matter of determining legislative intent and giving effect to it.
Well,
And
let me, in connection with that, let me ask you to address what Section 782.04,
okay.
the first-degree murder statute says. Now, it says in a pertinent part, I think, that the unlawful killing of a human being when committed by a person engaged in the perpetration of or in the attempt to perpetrate any aggravated child abuse is murder in the first degree.
That's correct. That's absolutely correct.
Why doesn't that just perfectly cover the circumstances here?
Because the state also says in 782.4 that we want the state to prove murder by premeditation, except in a narrow class of cases which like kidnapping and robbery, which do not merge with the homicide. Aggravated battery is a special form of felony in the sense that and this is what you recognized in Brooks.
You're talking about aggravated battery. I'm talking about aggravated child abuse. I don't think aggravated battery is listed in this list, but aggravated child abuse is.
You're exactly right. And up until 1984, the legislature had specifically excluded aggravated battery. Why? Because of the very problem that's inherent in the merger. That is that the battery, which let me finish here. I'm sorry.
No, go ahead. I'm sorry.
The acts that create the aggravated battery become the acts which also result in the felony. Now, in 84, they added aggravated child abuse. In Brooks, you recognize that aggravated child abuse is nothing more than an aggravated battery on a child.
I don't think the majority even talked about this statute.
Well,
did they? Did I miss that?
In Brooks, that's what you said. You said aggravated child abuse.
Well, but was there ever any in that majority opinion? Now, some people on the court recognize that, but I don't think there was any analysis of what this statute actually says in the Brooks majority opinion.
Well, I think what you said in Brooks, as I read it, is.
Well, I understand what we said in Brooks, but I'm asking about the statute.
Well, I mean, when you said, did you specifically analyze 82.4 in the sense like that? No, you didn't specifically say, but I don't want to give you the idea I'm conceding this point.
I don't expect you to concede it. I don't.
But I mean, clearly, an aggravated child abuse is I'm just quoting your language in Brooks, is an aggravated battery on a child.
But listen, I was on Brooks, and I'm looking at this and reading the other cases, and I want, since you're only making an argument about statutory construction, you just said that the legislature specifically added aggravated child abuse in 1984, as a form of that if that felony is proven, that it's first-degree murder. What else, it could be more clearer of a statement of legislative intent than the fact that it was excluded and then it was specifically included?
Well, I think what you have to look at is it's simply unfair to the defendant to have to defend just simply on just to allow the state to prove great bodily harm as his intent.
But guess what? You just said this isn't about fairness because you said it doesn't rise to a constitutional level. It's about legislative intent, and that's what I'm asking you. Now you're switching to that's not fair. And there could be a situation, and I could see a situation where a child is under the age of 12, and there's a single act of that causes a murder, and then there's sexual battery. Child abuse, plus that they're under 12, and all of a sudden there's 3 or 2 aggravators, and someone may make an argument that there's some constitutional infirmity, but that's not this case.
I'm not saying that aggravated child abuse can never be the underlying felony in felony murder. I'm trying to recognize the legislative intent. To give effect to aggravated child abuse can be a felony in the felony murder context. But in this case, I'm saying you cannot do that because the underlying felony, that the acts which become the underlying felony also merge with the become the acts.
I understand your argument. You're saying it's just like aggravated battery, but the problem with it is that aggravated battery is not listed as one of the felonies, and aggravated child abuse is.
And to give effect to the legislature in instances where that aggravated child abuse, the acts do not, the conduct does not merge and cause and become a causal factor in the felony, in the murder, then you can use it. But when those facts merge with the facts giving rise to the murder or homicide, then aggravated child abuse is limited in that context. I'm not saying you can't use it. But when
I just don't see how you could possibly draw that out of what is said here in the statute. It's unequivocal. I mean, it seems to me that the only thing you can conclude from this statute and what the legislature actually says is that if a defendant sets forth and commits an aggravated child abuse, and as a consequence of that, a death is caused to the victim, that is going to be a first-degree murder.
Well, then, Your Honor, are we re-examining Brooks? Is that what you're doing?
Perhaps.
No, you should not do that. That's what stare decisis is about.
But we were asked to do that in any event in 2 cases that have been certified by the First District. And I can say that, precedent is important, but if it's based on a faulty premise, then it has to be re-examined.
Well,
and in this case, in any event, you've got the sexual battery as a separate felony for that. So I wonder about the overall impact of, if it were error, their state's alternative argument that it would be harmless. Do you want to just address that real quickly?
Well, as to harmless, I go back to Justice Quince's observation. This was a general verdict, and as a matter of law, if the aggravated child abuse is invalid, it merges, then as a matter of law, you cannot say because they could have also found sexual battery, therefore it's harmless. That's what Yates versus United States says in a general verdict. When there's multiple ways of proving something,
did they find sexual battery separately, or that was just a felony? Was there a separate
Yes.
felony of sexual battery?
Yes, they charged him with.
Well, so then we know they found sexual battery.
But, well, like I said, this is what Yates versus United States says, is when there's multiple ways of proving something and one's wrong, you cannot assume they would have found it under the other way.
Except we can if they found it. Can't we?
No.
I mean, they found they did it in their verdict. They found a separate count of sexual battery.
Well, like I said, I'm relying on just as a general verdict. That's what I'm saying, is that under a general verdict you can't do that.
The sexual battery is under the same statute as the aggravated child abuse, is it not?
Under the felony murder statute, 7082.04, that's correct.
Okay.
Okay.
But didn't you make an argument that there is some issue with the sexual battery? Is there an issue of whether or not the victim actually consented in this case because he was charged with a particular kind of sexual battery?
Yes, sexual. Yeah, they charged him with sexual battery, and I'm arguing here that because the child was 13 years old, they had to show her lack of consent. And what the circumstantial evidence shows in this case is there was no lack of consent. I mean, I'm sorry, there is no evidence they showed of lack of consent.
So, but what we have really here is the defendant's version of the case, which says that this young girl that he had never really met before came knocking on his door to ask for a cigarette and ended up consenting to having sex with him.
That's correct.
And what else do we have other than that?
Well, you also have the other evidence. She asked for a cigarette. There was nicotine found in her blood, which corroborates his version of what happened. You also have evidence that from the medical exam there was no damage to her vagina or anus, which would be also evidence. Had there been damage in those areas, would have been evidence of lack of consent. The other evidence, other physical evidence, confirms his story. Her underwear, which oftentimes is used as a gag or to tie up the victims, was just simply shoved under her body. There was no physical evidence.
Well, do we know what the physical size of this young girl was in comparison to the defendants?
Well, I think she was smaller, but I don't see. I don't see how that really makes.
It seems to me. I mean, you're making a point of that her clothing was just shoved under there. I mean, he may have. If he was so much bigger than she was, why would he need to physically tear the panties off of her or anything like that?
Well, I mean, this is again circumstantial evidence. The fact that there wasn't any evidence of any force used goes to the show that he confirmed that she gave her consent. I mean, we're talking. I mean, we can make up all sorts of hypotheticals of what could have happened, but here's the facts that did happen. Those and this court has recognized that when you look at these sexual batteries, when you see evidence of torn panties and bras used as to tie people up, that's evidence of a lack of consent. There's none of that here. And we have, in fact, here we have a young woman who is very comfortable being around older men. He had knocked on another man's door, was walking his dog, would go into his room at night and watch movies with him. So this is not a woman.
Well, isn't there also evidence in the record that indicated that she was shy and was reluctant to talk to people until her siblings had talked to them? I mean, so you can come to different conclusions based on different elements of the evidence and the record on that particular point.
Well, I wouldn't call her shy when she's walking around knocking on people's door to walk their dog. She's going to grills that people have barbecues out. She's taking meat off their plate. I mean, she's shy in the sense that 13-year-old girls, I suppose, are shy, but I don't see really any shyness here.
Well, what happens, what is the significance of her age? Your argument might be different if she were 23. But at 13, which is barely a teenager, where does that factor in a circumstantial evidence case as to whether it is logical to assume that she walk into a room and voluntarily have sex with a man 20 years older than her?
Your Honor, we live in a different world than you and I grew up in. Where people at 13, when I was 13, and you were 13, we live in a different world. This girl apparently, I mean, the shyness that Justice Kennedy is alluding to, I just don't see a lot of evidence of. She's going around asking for cigarettes. She's walking dogs.
Beside the different world issue, I'm asking this because this is a question whether the jury could have found sexual battery, whether there is enough evidence for this to have gone to the jury. Is that what we're dealing with here? So what I'm asking you is that in looking at the circumstances, what circumstance is there as to the age of this victim, that she's 13, not 23? I mean, what is as far as consensual sex, she can't be, isn't there something even about whether she could have consented to sex with somebody over the age of 18?
I think that would probably be on lewd and lascivious conduct. But with the sexual battery, I believe 12 years old is the cutoff for consent and lack of consent.
So does the age play a part in a jury, in it going to a jury? That is the same facts, that is the pants, her clothing is not torn, but she's 13, not 23.
Are you suggesting that because of her age then, she was perhaps intimidated and
I'm suggesting that's a circumstance that in evaluating all the facts of her not knowing this defendant, of everything, you know, all the other circumstance that Justice Kennedy put out, that it's unlikely that she would have voluntarily gone into this room to have sex with this defendant, that's a circumstance that the jury could consider, or is that just speculation?
Well, that was what I was going to get at. It sounds like speculation. You got to have, I mean, just simply age by itself. I mean, you're speculating, and that's what I hear.
I didn't say age by itself. I said as one of the circumstances.
But there's nothing, nothing to support the fact that she was unusually shy, or even, you know, even particularly shy. I mean,
Well,
to the contrary, evidence shows she.
Is there any indication in this record that even if we accept that at some that she started out as a consensual act, that because he then started to strangle her, it became a non-consensual act?
No. In fact, what he said is we had sex, and then after that, he began to strangle her. So the sex, everything about the sexual act, all the evidence supporting the sexual act.
I thought there was some indication in here that at the time he started strangling her, he had not fully completed the act, that he had not disengaged himself from her, and that there was some indication that he began to strangle her at that point. And
No,
so,
I'm sorry,
would any consent, if that is the case, would any consent then be withdrawn?
If that was the circumstances, that they were still engaged in sexual, and he began to strangle her, then yes, their consent would implicitly be withdrawn. But what he said, when questioned by the police, in fact, the police specifically asked him, was this a blitz sort of thing where you, exactly what you're saying, during the sex you began to strangle her? And he said, no, I had stopped having sex with her, and that's when I began strangling her. So he, the defendant himself, is clearly saying the sexual intercourse had ended before he started strangling her. So no, I'm sorry, that's why we're raising this issue now in this context, is because there is a clear demarcation, and the evidence supports this. There was a clear separation between the sexual intercourse and then the subsequent strangulation. So what I'm saying here is the evidence, the circumstantial evidence, what it shows is exactly what I've said, is that Mr. Kaylor, this girl came into the room, asked for a cigarette. They started some sexual pre-sex sort of activity. They then took off their clothes, engaged in sexual intercourse, after which the defendant snapped, strangled her, and killed her, and then put her body under the bed and left. I'd ask this court to reverse the trial court's judgment and sentence on at least the 2 points I've argued here. There's some other points which I think are fully covered by the briefs, but I'd actually reverse the trial court's judgment and sentence. Thank you very much.
Well, let me just ask you this. I mean, if we found one or the other not applicable here, the sexual battery or the child abuse, don't we still have enough evidence in this case for a form of premeditation? Even from his own statement, it seems that at some point he formed the intent to kill her, independent of whether or not there was a child abuse or a sexual battery.
Well, I go back to, thank goodness, I go back to Yates versus United States for the general verdict. That when you have a general verdict, you cannot you as a court cannot parse out the actual basis upon which they determine.
I thought that Yates had to do with when the crime was legally insufficient, not a question of the factual insufficiency. Am I incorrect on that?
I can't recall. I'm sorry. Thank you very much.
May it please the court. Meredith Carbula, Assistant Attorney General for the appellee in this case.
Could you go to the sexual battery? I know that but just what is the evidence that allows this to go to the jury on the sexual battery?
Well, of course, consent, I would submit to you, and I think the case law is pretty well established in that, is that, consent, sort of like intent, is a matter uniquely for the fact finder. And I think that, as long as there's competent substantial evidence that conflicts with his hypothesis of innocence. And I don't want to concede this is a circumstantial evidence case, because I think, courts have continued to struggle on the notion of whether a case is wholly circumstantial, whether the special burden applies, or whether simply one element is circumstantial, therefore we have to apply the circumstantial evidence test, which I think this court shouldn't do. This court has done it, but when you say a case is wholly circumstantial, then we apply a special. But here we have admitted sex, we have the DNA in her vagina, so this is not a wholly circumstantial evidence case. But in any event, we have evidence from Billy Lawton, who lives with MH in the Value Lodge in Panama City. He testified that she was reserved and shy. Scott Heinze, who she did befriend, and she met him, and she befriended him. They cooked, Heinze and his roommate, Tater, cooked out and invited the kids, MH and her brother, to cook out and things like that. And she walked his dog for a part-time job. So he also testified that she was quite reserved. She wouldn't talk to anybody at first until her brother talked to her, talked to him until she got to know him. And once she got to know him, then she would, come on her own. But
she was they were living in a one room, was it one room?
Yes,
And who was in that room with her?
MH's mother, MH's older brother, CH.
How old was he?
16. At the time of trial, he was 16, so I guess the murder probably 15. And 2 adult males.
And how old were they?
I don't know.
It wasn't established in the record?
I don't recall it being established in the record, the age of either one. They were both adults, at least in their 20s, because they were, one of them was MH's mother's boyfriend, and then a friend who was staying with them.
There was no testimony about her relationship with those 2 older men?
No, absolutely not. So that's who she was living with. And
what was her prior contact with this defendant? Because as I understood it, she may have accompanied her brother once when he came to give some kind of tape or knife or something, but other than that, there had been no contact?
Exactly right. Kaylor told the police, and the thing is, the jury rejected Kaylor's claim that the sex was consensual. Billy Lawton told the police and testified at trial that Kaylor asked to borrow duct tape around noontime the day of the murder, and then a few hours later, a steak knife to eat his dinner, and that on one of those occasions he thinks MH went with him, but he also testified that Kaylor wasn't paying attention to him. He barely opened the door, and there's no interaction as far as we know. We do know that Heinze lived 2 doors down from Kaylor, and MH walked Heinze's dogs for, as I say, a part-time job. So we have that evidence of shyness, and I think that it's really critical when you look at the evidence of shyness in Justice Speriente, the age of 13. So we have a reserve girl, and I do want to make a point, because in the reply brief, appellant claimed that the record supports that she wasn't shy because of, among other things, she was selling marijuana. Absolutely not supported by the record. The 2 cites to volume 19, nothing about selling marijuana, and the other side is to Matthew Kaylor's statement, where he's asked, "You knew her name?" "Uh-huh." "Did you know her brother and family?" "Yes, they came around to sell marijuana all the time." Even if you believe it, it wasn't MH. He never accused MH of selling marijuana, and that's absolutely not supported by the record. I'm sure it's inadvertent, of course, but it's absolutely not supported by the record. But what's really critical when you look at her shyness versus his testimony, he says she knocks on the door, his closed door, so he has to go and open it, asks for a cigarette, comes and sits next to him, and says, "You're hot." Puts her arm around him. And, one thing leads to another, and he starts, takes her for clothes, she takes off her clothes, they start having sex. Absolutely inconsistent with evidence from Billy Lawton and Scott Heinze, both who knew her. That she doesn't go and just talk to strangers, she has to get to know him. She goes first with her brother, CH, and only then does she get to to know someone, will she come and talk? Even, this notion of her going to Scott's room a lot, she walked her dog. If you look at his testimony, he said mostly she came with her brother. Sometimes she came by herself, mostly she came with her brother. So we have a shy girl, testimony from people who know her, in contrast to Kaylor's testimony that she knocked on his closed door, she came in, she sat down, she said she didn't even like Scott Heinze and his roommate, but gosh, you're hot. She's the sexual aggressor. Absolutely inconsistent. And that evidence I would submit. You've got a 13-year-old child on her period, shy and reserved, is now suddenly the sexual aggressor that Matt Kaylor can't resist. It's simply inconsistent. That was sufficient to go to the jury.
Well, he argues that one of the reasons that, in addition to Mr. Kaylor's statement that it was consensual, that there was no, ripping of the clothes or any of that kind of activity to indicate her non-consent.
50 pounds. Oh, almost a foot taller, 50 pounds heavier, approximately. He's a grown man, she's a 13-year-old girl.
Is the motel like one of these motels where you open the door and it's the breezeway?
Yes, there's a breezeway, and there's the Tater's and Scott's room faced the pool, and so did Matt Kaylor's.
Okay, so I guess what's the state's theory about how she got into the room? Is it that she's walking around and he just grabs her and puts her in,
there's no evidence of that.
Or that she did come to ask for a cigarette? What's the state's theory on that?
Well, the state's theory is that she got into the room somehow. We don't know how she got into the room. We don't, I don't think the evidence absolutely support. I mean, we've got his testimony about how she got in the room. I have a theory about how she got into the room. That's, I think, a common sense thinking it out, how it might have happened. When she finished walking Scott's dog, she headed to the right, which was where Kaylor's room was. So I think it's fair that perhaps his door was open, he was out smoking a cigarette, there was some interaction. I don't believe that she knocked on that door. It just was absolutely inconsistent. I mean, she had just come from Scott's room. Why would she ask for a cigarette from Matthew Kaylor when she had just come from Scott's room?
But does the evidence indicate that she is in fact a smoker?
There was evidence that she would be seen occasionally smoking a cigarette, absolutely. And that was from Billy Lawton as well. So yes, there was evidence that she smoked.
The autopsy showed there was nicotine in her blood.
Absolutely, there was nicotine, but there was no alcohol and there was no drugs in her system.
What time of day was this?
It was 5 o'clock in the afternoon. She finished walking Scott's dog about 5 o'clock, and sometimes after that she was missing because her brother went to look for her and Billy Lawton went to look for her. So it's probably somewhere around 5:15 to 5:30.
And did they not search for her immediately?
Absolutely, they did. They did a search for her. Billy Lawton and her brother went out and did a whole search. They called the police about 7 o'clock when they couldn't find her.
And the police, they come immediately?
They came immediately.
And this room was cleaned 2 days in a row without discovering the body?
What happened was when Kaylor put her body under the bed and her clothes under her body on the bed, he left. And
the same day of the murder?
Yes, ma'am. He left. He left, and he was ultimately arrested on another charge involving the Russian woman who he alleged stole his cocaine. But what happened is the housekeeping crew came in and cleaned the room. But the housekeeping person, their back was thrown out. So she's supposed to check under the bed, but she didn't check under the bed.
Yeah, that's what they all say.
And Vince Wallace, a trucker whose truck broke down in Mississippi, checked into the room with his girlfriend about midnight, slept on the bed all night.
I'm just saying.
And then she cleaned and then another housekeeper crew came in the next day and discovered the body. So there was a thorough cleaning without discovering the body yet. One, yes. And the second time they discovered the body. And that was on the 10th. He, as I say, he was under arrest. And
They didn't suspect, I mean, did they suspect him as the perpetrator? I mean,
Oh,
was there
absolutely.
evidence about that?
Absolutely.
And the police didn't search the room after?
I'm sorry, not immediately. There had been no evidence. No one saw her go into Kaylor's room. Kaylor was asked by, I think, MH's mom or brother, or I can't recall which. He was asked specifically. They called and were trying to find her, desperately trying to find her, and he said, "Oh, that's too bad she's missing." Well, in the meantime, she's under his bed, having murdered her.
So I guess what we're trying to do, someone did ask him if he had seen her, and his answer was no.
Absolutely. And there was testimony in the record that evening, I think actually Kaylor called the room. I believe the testimony from I think it was from Billy Lawton, testified that Kaylor in that evening called their room. And during that conversation, he asked Kaylor, "Have you seen her?" And he said no, and oh, isn't it a shame she's missing? So that's how that happened. If I could go and talk about the Brooks issue. Number one, we don't have a Brooks issue because we have multiple acts of child abuse. We have, in the information itself, in Volume 1 of the record, you can read the indictment, and it alleges sexual intercourse, manual strangulation, and ligature strangulation all separately. Dr. Hunter, the medical examiner, testified that the ligature strangulation occurred when, in different places. In other words, just what Kaylor told the police that he had wrapped it around her throat and held it until she was dead. That's not true, not supported by the medical examiner's testimony. You can even see, if you see the photos, it was applied in different times at different angles. So he has applied that ligature. When it doesn't work, he reapplies it and kills her that way. And Justice Quinch, you talked about premeditation. After he manually strangled her, and I think going back for just a moment to the issue of whether the sex act had been complete, he told the police that he was still straddling her in the missionary position and her legs were still spread. And when he was asked about blitz, he talked about how, yes, it was, he pulled out of her, according to him, and there's actually no evidence pointing to that's the case. But he pulled out of her, and then that's when he began to choke her. But he was still straddling her and in the missionary position, and her legs were still spread. But after he manually strangles her and isn't able to finish her off, he gets up off the floor, goes across the room. Now, admittedly, it's not a big room, but he tells the police her body is by the refrigerator and the phone cord is on the other side of the bed. He gets up, he goes and he unplugs the phone cord from the wall. He unplugs the phone cord from the phone. He brings it and he applies the ligature several times, numerous times. And so, yeah, absolutely, there's absolute evidence of premeditation. And in any event, we really don't have a general verdict, and Justice Perrienti, you got it. There's a separate finding of sexual battery for, even if there's a Brooks issue, which there's not, because there's multiple acts. And in Lukehart, in the case you cited to in Brooks, in Lukehart, you distinguish that from Brooks. In Brooks, you did that. In Lukehart, there was like 5, I think, blows to the head that caused the death, and there was no issue on that. Of course, I would love for you to reconsider Brooks because, of course, it's aggravated child abuse is an enumerated under the felony murder. And if you look at the history of the merger doctrine, the merger doctrine stemmed from common law. And if you look at the states that are applying it, for instance, I think in an appellant's brief, he cited to Godsey case. It's a case out of Tennessee, has a really good discussion of the evolution of the merger doctrine, how that came from common law to sort of narrow the list of felonies. And that's applied in states where there is no enumerated felonies, or if there are enumerated felonies, there are the catch-all, such as robbery, burglary, sex bat, and any other forcible felony. So you have those states applying the merger doctrine in those cases where there's no enumerated felonies, or if there's enumerated felonies, then there are catch-alls, which then the court, if they're charged under the catch-all as opposed to an enumerated felony, the court then has to look and see whether those cases merge. So I think that it's of course, Yates looks at the really key part of Yates, and going back to what you said, is it's got to be impossible to tell that the jury found the defendant guilty under a legally adequate theory. And here, of course, we know. Found him guilty of sexual battery as well as aggravated child abuse, so we do know.
Was the, you mentioned that in the information they charged as the acts for the aggravated child abuse, both the acts of the multiple acts of strangulation as well as the sexual battery.
Yes, ma'am.
Was that argued to the jury that way too? Or did they limit it to the strangulation?
It was argued every way. The jury was instructed on, as far as aggravated child abuse, was instructed on the willfully torture and on the willfully and intentionally inflict child abuse where great bodily harm is had. And they did not argue, nor did the judge instruct on aggravated battery as a theory of aggravated child abuse. But if you look at the indictment, and that's on page 3 of the record, they charge aggravated child abuse, penetration, and in the process thereof did through the repeated application of manual and ligature strangulation cause the death of. So we have that charged, several acts, but of separating out the manual and ligature strangulation, and that's of course supported by the medical examiner when he testified that the ligature strangulation, he couldn't tell from the manual strangulation, there was just so much injury, but what he could tell from the ligature was that it had been applied and reapplied on several different angles, so he was able to determine that there were, even if we only charged ligature, there were multiple acts of ligature strangulation. So I think that the fact is that we don't have legal inadequacy for aggravated child abuse because even if Brooks should stand, Justice Lewis, it's an enumerated felony. And, but even if Brooks should stand, we have multiple acts, so it's outside of Brooks in any event. But certainly this court may, and I respectfully suggest should, revisit Brooks, simply because I think as you've accurately pointed out, aggravated battery is not an enumerated offense, tracing back to Mills, and aggravated child abuse is, and that's what we have to look at. When an issue is legislative intent and statutory construction, you first look to the legislature, and when the legislature says aggravated battery, Justice Lewis, you said in Brooks' dissent, there's nothing in the legislative intent that says it's got to be more than one act. And so even if we had one act, which of course we don't, it's clear in legislative intent that aggravated child abuse, and of course we see why. The legislature has deemed fit to protect certain vulnerable individuals, and also in enacting the felony murder statute. And I see actually nowhere in the statute that says we prefer you to charge premeditated murder, and this is just sort of a red-headed stepchild. The statute sets out clearly that you can commit murder in 2 ways, which is premeditation or felony murder, has identified crimes that are so inherently dangerous to human life that to deter people from engaging in such things that are so inherently dangerous to human life, then it's felony murder. And child abuse, elderly victims, those sorts of vulnerable individuals, the legislature has chosen to make that an enumerated felony. And so I think this is a good case to do that. And
what is the I don't know if this goes to any specific issue, but it's addressed as far as the remorse. The PSI was sealed. Was the PSI used in any way in this case?
Yes, ma'am. The judge used the PSI. She mentioned the PSI in her sentencing order, and the PSI is in your record. And I think if you look at the PSI, you'll see why the trial court put little weight on the remorse. Long before he knew that remorse was a mitigator, he talked about how it was her fault that he was in this situation. And if, though he did express remorse at the Spencer hearing, if you look at the PSI, then, Matthew Kaylor told the probation officer preparing the PSI, talking about the death of this child, how do you tell the mother that it's because how she was raised? That's what he said. And that's in the PSI, and the trial judge had that when she considered whether he was truly remorseful, and she considered remorse. She took your admonition to her in the Orm case where she had to consider remorse, and she did consider remorse. But it's within the discretion of the trial judge the weight that she puts on mitigators, and she separately considered his issues of mental health, and she found the extreme emotional disturbance based on his past. But it's up to her to put on the weight. But in this case, it's like one of the best cases, I think, or one of the most cases you can see how clearly putting little weight on remorse is because of what he said. I mean, to the police, the policeman asked, do you have remorse? Are you remorseful? Oh, yeah. I'm going to be locked in the rest of my life for this. That was his expression of remorse. Same thing sort of in the PSI. And, I think the trial court was well within her discretion to give little weight to that, especially since he was so inconsistent. And, when he thought we weren't looking, that's when he really expressed how he felt about this case, which was, man, it's her fault, not mine. So with that, I would ask this court to affirm Kaylor's convictions for first-degree murder, sexual battery, and aggravated child abuse, and affirm this death sentence. Thank you.
Couple points. This is not a case where he drags her into his room or evidence. There's no evidence that she knocks on his door. She had to come see him. Why else? I mean, she ostensibly wants a cigarette. Well, this goes back to the lack of evidence of consent. Kaylor is not going out by the swimming pool and pulling her into the swimming pool. There's no evidence of that. The evidence is that she came into his room and they got sexually excited and had sex, and that shows she consented to whatever happened, at least as far as the sexual intercourse goes. So for that reason, I'd urge the court to reverse the trial court's order and for a new trial. Thank you.
Right, the court will now take a 10-minute recess.
Please rise. Florida Supreme Court is again in session. Please be seated.
We now come to the second case on our docket today, Boatman versus the state of Florida.
May it please the court, I'm Gail Anderson, representing the petitioner Rayon Boatman. In the argument today, I'd like to emphasize a few points and...
Can hear you.
Is that better?
Better.
I'd like to emphasize a few points, and of course, I'll be glad to answer any questions from the court. First, the first DCA said that it was certifying the question, which is before the court, quote, because this issue appears to be one of first impression, end quote. This means that before the first DCA's decision in Mr. Boatman's case, there were no clear rules regarding preservation of a claim that a trial court in a civil commitment case improperly continued the trial beyond the 30-day limit mandated by the statute. That there were no clear rules is also evident from the state's brief in the appeal in the first DCA, where the state raised no waiver issue.
Well, let me ask you this. As I understand this case, the probable cause, the state asked for a continuance of the hearing that would take place to determine if this defendant was a sexual predator, correct?
Correct, a continuance of the trial.
And then the hearing on that was in fact held within 120 days?
It was scheduled for 120 days from the finding of probable cause. It was actually put off one more week.
It was put off one more week pursuant to the continuance.
Yeah, the continuance was for the 120 days, and then there was a stipulation for one more week.
And so I guess I'm at a loss as to why we even have this case, since under the rules, you can in fact ask for continuance. It seems to me that the case then went to hearing pretty expeditiously after that point. So why are we here?
Because there can be a continuance under the rules under the statute of 120 days if the respondent is not substantially prejudiced.
Well, he was substantially prejudiced by an additional week?
No, he was substantially prejudiced by the additional 120 days.
How? Because
his prison sentence expired. The state filed its petition on October 1st. Mr. Boatman's prison sentence expired on October 5th. This is exactly why the 30-day limit is in the statute, because to avoid holding people after their prison sentences expire.
So are you equating substantial prejudice with the fact that a person will be in custody past the expiration of the sentence?
Yes.
So that would not be then a discretionary call by the trial judge. It would be law. That is, that there's sort of, even though the statute doesn't make the distinction between those whose sentence would expire and those whose sentences have not expired, there would be two different standards for substantial prejudice. One, if their sentence has expired. So shouldn't then, if that's the case, shouldn't the statute just have read that if the person's sentence is expired, there shall be no extensions for any reason? And it's concern. I understand what you're saying, and I understand what the first district's saying, but they first say there's discretion, but really you'd be saying no matter what the reason, whether there's good cause or not on the part of the state, that there cannot be a continuance past the 30 days if the person is that what you're advocating for?
In part. I think there would be could be other circumstances where a person would be substantially prejudiced.
Oh, okay, but where their sentence is expired, there then should never be an extension beyond the 30 days.
Certainly not for 120 days.
No. First, I'm saying for beyond the 30 days.
Correct.
But you're saying, well, the fourth district has said 7 more days was okay.
Right.
And your own, and this is one of the problems, and I understand that this is a difficult case on many levels, but I'm struggling with this, that the lawyer for Mr. Boatman asked for a adversarial probable cause hearing. What is the purpose under the statute for the adversarial probable cause hearing?
It is for the state to present live testimony and the defendant to be able to hear the testimony and cross-examine it. And
so it's additional, is it additional protection that somebody that ought to be free is that there is substantial evidence against that individual?
I think so, but
so it didn't. My question then is, the lawyer asked for it, but there's nothing in the record that there ever was one.
Right.
And then they stipulated to an additional continuance to February. They never said at the point when the judge was saying, well, I think there is a basis for continuing this, and I'm going to ask the state. I do have concerns about whether there is good cause. If there's no good cause, then you don't get this substantial prejudice. But as to then say, well, give us, another 30 days, but don't give them 120 days. So how does that work? I mean, the defense lawyer didn't ask for something short of the 120 days, stipulated to the additional week.
Right.
How does that fit in the mix?
I think the defense attorney was asking for what he thought he should ask for. And that is that the statute says have the trial within 30 days of defining a probable cause. And once he lost that issue, what else was he supposed to do? I mean, there were no rules anywhere telling him what he was supposed to do.
But here's the problem, is that because of the case that I dissented on, but was the majority, that says the dismissal is without prejudice.
Correct.
My concern is that the right that we would be vindicating, the right to be out of custody before there's a determination that somebody is a sexually violent predator. Wait until after the trial to vindicate a pretrial right and say the remedy is that they now, even though he's been declared and all the evidence is in that a jury unanimously found him to be a sexually violent predator, you would be asking us to actually say, no, he now gets to be released and you get another chance to have this case tried while we have somebody who's already been declared a sexually violent predator out. I have a real difficult time in terms of the appropriateness of that as the remedy when there is no issue as to the fairness of the trial. Nothing where we were substantially prejudiced by waiting. We have a case where someone's been held for 8 years. I mean, now we have a different issue where there's nothing in this case that says something unfair happened during the trial. How is that an appropriate remedy on appeal?
Several points, Your Honor. First, in this particular case, the state took that risk. They waited 3 months to file the petition. They asked for the continuance. Second, this has happened before in State v. Kinder. Kinder did move to dismiss in the trial court for violation of the 30-day limit. The trial court denied the motion. Kinder filed a petition for writ of prohibition in the second DCA. But while the second DCA was considering that petition, the trial went forward. And so he was tried. The second DCA said that the remedy for him and for that violation of the 30-day rule was release. The case came up here, and this court said the second DCA was right. So there's already been a case where this kind of thing happen. Where
This
the
doesn't
trial
make,
had
I
already
guess I'm
happened.
having trouble with it making sense. And listen, the law in this area, extremely quite complex, trying to balance everything. And I agree with you, why I think that I agree with the First District. I'm not sure how the state shows good cause in this situation, so you don't get to the substantial prejudice. But in terms of the remedy, the best analogy that I was thinking of, and I want to ask for you to tell me why I'm wrong, isn't it analogous to pretrial rights to pretrial release on conditions for bail, bond? That is raised traditionally as a writ of habeas corpus. Nobody would suggest that if you wait until after trial, somehow the remedy would be a retrial with the person out on the proper conditions of bail after there's been conviction, and set aside that conviction. Why is that a bad analogy? What's wrong with
I think the analogy doesn't work because of the particulars of the Rice Act, and which gets into the sub-issue involved in this case, is whether once a Rice Act respondent is released, can the state file the petition again? Once the Rice Act respondent, if the 30 days is exceeded, Osborne says the remedy is release from detention and dismissal of the petition without prejudice. My position is when the petition is dismissed and the respondent is released, the state can't file another petition until that person comes back into custody for
Well, then
some
you're
reason.
asking us to recede from Osborne.
No.
Well, without prejudice would be meaningless if the idea was you had to wait until he actually committed another sexual act or any act until he put himself back into prison.
What without prejudice means, the way I read without prejudice, and I think the second DCA has read it the same way. Without prejudice means it's not a decision on the merits. It does not form a res judicata bar to a proceeding somewhere down the line. And that's what happened in Ray Commitment of Good, which is the second DCA case that followed this court's decision in Good. Good was released while this court was deciding his first case, where the state had filed a petition. He was released. Some point later, he was arrested for, I'm not sure if it was violation of probation or a new crime. In any event, he was resentenced to prison. The state then filed a second petition to civilly commit him, and the circuit court dismissed that petition, ruling that the prior dismissal was a decision on the merits. The state appealed that to the second DCA. The second DCA said, no, the prior dismissal was not a decision on the merits. And so they were able to proceed against Good on the second petition. I think that case is the example of how this procedure would work.
You are now down to about 6.5 minutes into your rebuttal time.
Thank you, Judge. Let me see if... I do want to say that since the first DCA recognized that its decision was one of first impression, if the court adopts some rule analogous to what the first DCA adopted, it shouldn't be applied to Mr. Boatman. There are no clear rules about this right now. And there has to be a clear rule in order for somebody to be held to have waived a claim. And I'll reserve the remainder of my time. Thank you.
Good morning. May it please the court, counsel. Tom Duffy on behalf of the state. A couple of follow-up points that I'd like to make. Counsel defense counsel was on notice from the Osborne opinion itself as to one way to proceed. Osborne moved to dismiss.
Mr. Duff, let me ask you this question as we go through. Each time we've had one of these cases of first impression, because this is a new concept, many thought foreign to American jurisprudence, but I mean, we've learned to the contrary. And as we step forward, we've made some of these interim decisions. But as I see a case being asking this court whether an extraordinary writ is the only way to get review of a judicial act or of conduct, is there any other area of the law that mandates that an extraordinary writ is your only means to protect yourself?
Well, the first step is to file a motion to dismiss in the trial court, and that's what Judge Webster's opinion said, that you file a motion,
So I mean,
and then a habeas to appeal.
Well, that's what I'm saying. Is there any other area of the law, as a lawyer standing here practicing appellate law, are you aware of any? Because I don't know of any where any court anywhere in the universe has ever said or limited the rights of an individual, particularly under the American jurisprudence system, that an extraordinary writ is your only way that you can get review of this act you complain of.
I don't know that that's presently true. I suspect it's been true in the past before civil procedure rules became common.
Well,
in American jurisprudence.
I'm asking a civil rule in Florida, a civil rule anywhere, federal civil rules anywhere.
No, the civil rules, maybe I didn't make my point clear, Justice Lewis. The civil rules make the writ practice unnecessary. That once you have a rule of procedure in place, you don't need to go to an extraordinary writ. And the extraordinary writ here would only be in the way of taking an interlocutory appeal.
Well, that's not required in any place, in any law that I'm aware of, and correct me if I'm really trying to understand this. No, I know of no rule of law that says if you don't take an interlocutory appeal to an adverse ruling, you've waived everything. I don't know, is there such a rule?
I suspect there is. I can't think of anything off the top of my head.
Well, I've looked, I don't find anything.
That what you're saying is that you don't waive an interlocutory appeal by
You don't waive a final appeal by not taking some extraordinary interlocutory kind of relief.
Well, let's take the case that Justice Periente talked about, where there's bail.
Okay, then is this one? Is this like bail, and how does that operate?
It's not precisely like bail, but it is kind of like, in some respects, pretrial detention. There's two rules in the rules of criminal procedure, which we normally stay away from because we don't want to mislead the court into thinking these are criminal actions. But I believe they are 3.133 and 3.134, where a defendant has a procedure whereby he can be released if the state doesn't file an information within X number of days. And the two rules are really sort of complex in their interaction, but eventually, let's say a trial court did not release the guy under 3.134 after 40 days expired. If he didn't appeal that, what's his remedy? His remedy was to get out, and that's what the remedy was here, to get out and to make the state start over with another petition.
And those are two rules of criminal procedure that you believe we could look to for guidance as to what should happen under these circumstances.
Well, if you're dissatisfied with Judge Webster's scholarly opinion that we wholeheartedly endorse.
What is the authority for saying you have to take an extraordinary writ or you've waived it forever?
That's the only procedure available. And
that's not authority. That's not authority. Come on now. When we're speaking of authority, a rule, a case, a decision, a statute, a constitution, some kind of authority for that. That's just because he says it doesn't make it right.
Well, there was any case of first impression doesn't have express authority. That's what makes it a case of first impression.
How about a principle of law?
The principle of law is that you defend and protect your own rights. And in this case, what he had a right to was to be released. He did not pursue that right. The only way available for him to pursue that right, to get an immediate release, would be to file a motion to dismiss, And if that's denied, then seek habeas corpus relief in the
And
DCA.
that's because this court has held that any dismissal is without prejudice? Is that where that flows?
Doesn't necessarily flow from that, but it involves it. That's what lets the state go forward. Otherwise, it would just be motion to dismiss with prejudice.
Let me ask you this
Why
question.
should we not follow what she has suggested that's happened apparently already?
Are you speaking of the Osborne case?
A good case.
Oh, good. Yeah, the good on remand case. That's the way it happened there, but that's not the way it had to happen. That was the procedure that occurred. In fact, what good stands for, good on remand, the second DCA's good decision stands for, is the proposition that just because you got a get out of jail free card one time doesn't mean you've been adjudicated on the merits.
Yeah.
So, and that's just the way it happened. The state, I mean, if somebody were released or potentially even found by a jury not to meet the criteria, if there's another event that occurs, presumably the state could go forward on that, especially if it was another sex crime.
Sure. I mean, that's
So good
absurd to
really
say
doesn't.
it gives you you're free to do anything you want in society. I mean, certainly that's absurd thought. But again, I mean, she's saying you have to come back into custody, not necessarily for a sexual offense, but back into custody, as I understood
But
the
that
argument.
makes it with prejudice. If you can't refile and apply the relation back doctrine
Until
and
they're in custody
refile,
again, yeah.
that makes it with
For all
prejudice,
purposes.
so that just eliminates Osborne.
I have, just in terms of the argument about the reason it has to be raised pretrial, here it appears that the basis for the substantial prejudice finding is that the sentence had already expired, and therefore he was in custody solely on this civil commitment. If his argument had been that the judge abused his discretion or her discretion in granting the continuance because the substantial prejudice had to do with the ability either to prepare for trial or something regarding the trial, would it be different in terms of the remedy? Do you see what, in other words, sometimes a continuance, when we say the judge either denied a continuance or granted a continuance, affects something in the trial proceeding, and at that point then you look and say the remedy would be a new trial. But, and this is sort of a friendly question here, where the only allegation is not that the fairness of the trial was affected, but that they had a right to be released from custody, is that, I mean, and again, understanding that this is something that maybe there should be a rule to address it, like there is for pretrial detention, is that different, and is that the reason we look to say you really have to vindicate this right pretrial? So is there a distinction between the reason that they're alleging there was substantial prejudice?
I think you made the valid distinction there. The substantial prejudice, we believe, would be something that prohibits you or restricts you in your trial preparation. That would be one example of that. Justice Quince had a good point that I believe we also brought up in our brief, which was that if you have, I'm sorry, I've lost my train of thought on that. Anyway, I would endorse what
But
Justice
we'll take
Quince
whatever
said.
her point was, we'll say, you say it was good.
And that goes double for me. Our position here is what the first DCA came up with on its own. We candidly admit that I wish I had thought of this brilliant ploy, but frankly I didn't. That sexually violent predator pretrial detainees waive or forfeit the right to challenge continuances unless they immediately seek some sort of relief. And
If the only, is there a caveat then? If their only basis for the substantial prejudice is their right to be out of custody?
yes,
I
and
mean,
that's,
shouldn't that be a caveat?
Well, I think this case stands for that proposition.
But that's not how the certified question reads.
No, it's not, but you can adjust the certified
And
question.
shouldn't we
to-
then really look prospectively to having a rule of procedure that is similar to pretrial detention so that it's clear?
Rules of procedure are very nice for that very reason, and to get us around the problem that Justice Lewis mentioned.
And I'm very concerned, though. Let's go back to the state's actions here.
Okay.
The state had the ability to, there was, the multidisciplinary team was put into effect months before this defendant was due to be released. By July, there was already a report saying that they found that Boatman met the criteria for a sexually violent predator and should not be released. And the state, for no apparent reason, waited from July until October. Even if they thought he was going to be released in November, they waited 3 months to file this petition. They filed the petition, and then 1 week later, they say, oh, gee, one of our experts is out of the country, and they then say, oh, and plus he needs more time, the defendant, to prepare for trial. Are you suggesting under those circumstances that the state met its good cause burden?
Yes, we do, because apparently the release date changed. There's
But
nothing.
how much did it change by?
Well, at least a couple of months, apparently. One of the doctors had his release date as December 6th. The other one had the release date as November 24th. He was sentenced in 1994, so I suspect there was abundant game time available to him.
Nevertheless, if they would have filed it in October and thought he was going to be released in November and they were going to still ask for 120 days, he'd be held after his release date under that scenario.
I don't think they necessarily knew that the doctor in question was going to be
Well,
out
I don't know
of
how
the...
good cause can be that you just assume something that doesn't have any, that's really not established in the record as a basis. I mean, to me, good cause would have been something that they could never have anticipated, not waiting, again, because we want to make sure that the legislative right that's been established to be tried within 30 days unless. It's not a court rule. This is a legislative mandate, that is vindicated in the way that we apply this. So to me, I don't see a good cause.
The good cause in our mind was the fact that a crucial witness was unavailable. That's the ground the state argued at the trial court. And that's...
And wasn't going to be available, he was out of the country until February?
He was out of... I don't know. What the record shows is that once the continuance was granted, and I don't have that part of the record with me today, but once the continuance was granted, then scheduling took place with a discussion between the lawyers and the judge. And at that point, the next date they could coordinate was in February. So it wasn't that the state asked for 120 days. The state asked for up to 120 days, and for the parties to get ready.
The defendant said December, and the state said, no, that's not, and so it was the state that said over the defendant's objection, February.
I don't know that was objected to, but I'll take your word for it. You may have seen the record more recently than I.
Not
Let me
agreed
ask
to.
you about this whole sequence of events, because I thought that the trial judge had a sort of pre-trial hearing on this and appointed counsel for the defendant, and did he appoint experts, some additional experts at the defendant's request?
That request was made. I don't know when the experts were appointed or an expert was appointed.
And so, do you know in this record when we got any expert reports, expert examination of the defendant, any of all of that?
I don't know the answer to that question. I know that the petition and the ex parte probable cause were done on October 1st. On October 8th, the parties were in court. And on October 10th, the state moved for a continuance. Apparently, only then realizing that one of their crucial witnesses was unavailable in the 20-day, I'm sorry, on the 8th also, the October 20th trial date was established and agreed to initially by the state.
Let's assume that good cause is met. What is your argument as to the First District's error in finding that there was substantial prejudice? How would the state define substantial prejudice for the purposes of this statutory scheme?
Well, I think you already beat me to that with the trial preparation. That would be the crucial thing for a case like this, is that the continuance will somehow, and I don't know how, but somehow influence or restrict or damage your pretrial preparation.
Well, but they have an absolute right to the 30 days. So if the legislature meant for there to be an automatic additional 120 days, they wouldn't have put in the term substantial prejudice. I mean, we always think the more time people have for trial to prepare, the better, but not for somebody who is under the otherwise can be released, but for the state having filed this. So I have a problem with defining substantial prejudice solely in terms of trial preparation, because the defendant would never be able to establish that.
Well, I think in the proper instance.
How? If the idea is the state says we need more time to prepare for trial, the defendant goes, well, we need less time. And how would you establish substantial prejudice?
It might be a timing thing. In other words, the state wants, let's say a trial is set for, we'll say, hypothetically, within the 30-day period. The state wants a continuance also within that period. But during that period that the state wants the trial to be continued to, defense experts are not going to be available, or an important family member for the respondent is not going to be available, or there's some other event that would make it difficult for the trial counsel.
So you would not consider any effect on the right of the defendant to have been released, but for the state's institution of these proceedings to be at all within what the legislature would have intended in the phrase substantial prejudice?
Well, I think your Osborne decision indicates that will always be a factor to be considered, that you weigh and balance the interests of the defendant, and in that case, the length of the continuance would be a factor as well.
Isn't all of this confusion, the attempted complexities, the creation of rules of law that have never before existed, all a product of the failure to follow the statutory plan and scheme, which was that these are to be conducted before the end of a sentence? Isn't that where the and so we are visiting failure by whomever's supposed to do this on the shoulders of the court system, on the shoulders of people who are facing this lifetime imprisonment because of failure of someone else, and now we're looking backward trying to justify all that. Isn't that really what's happening?
Not necessarily.
Every case we've seen so far, that's what the case was.
Well, that's how you've construed it, but in this case, let me just mention one fact that wasn't in our brief, but I've discovered it in preparing for oral argument. The Department of Corrections refers these supposedly 545 days, roughly 18 months, in advance of release.
Isn't that what is contemplated by the statute? This all be done before a sentence is over.
But in this specific case, if you take the date that referral was, and it's in the record, that referral was on the 16th of October 2007. If you add 18 months to that, that shows a release date of May of 2009.
Well, that wasn't the Mr. Boatman's fault.
No, but it's not the state's problem either.
Wait. It's an agent of the state that's not done what they're supposed to do. Isn't that what caused it?
No, they didn't not do what they were supposed to do. Presumably, DOC notified them at day 545 minus release date. But release dates for people, especially for people sentenced in 1994, release dates are volatile. And they depend on a lot of different
But
factors.
isn't that, again, the people that have the person locked up have that knowledge?
Not necessarily. They didn't presumably in 2007, because these things change. Gain time can be lost. Gain time can be restored.
But those people know that? These are not some kind of rookie neophytes that know nothing about the system. They know all these things.
My point is they don't know it at the time because circumstances
And so we're going
change.
to, okay, so then that should be then visited upon the person who's subjected to the process, a court system that is trying to carry out the intent of the Florida legislature to the very possible, to its, as best possible. It seems to me is that there's going to have to come a time when we interpret the intent of the statute to mean what it says and apply it to what it says, then maybe we'll have some clarity to all of this confusion, because this is a haphazard application with people I read the opinion, just as we're sitting here again, there's not one authority cited for the principle of law. You waive all your rights.
First impression. That's all I
First
can say.
impression of any court, of any land, of the United States that said that you lose all your rights simply because you didn't take an extraordinary writ.
I'm not necessarily sure, I'm no legal historian, but I'm not necessarily sure that that wasn't the case in, say, the 1920s. My time has long since expired. We ask that you affirm the opinion, approve the opinion below. Thank you very much.
Justice Lewis, you're absolutely right that this situation occurred because the intent of the statute wasn't followed. The statute says that a year and a half before the person's release, DOC, which should know when the person is going to be released, should send the records to the DCF.
Now, counsel says, in all fairness, that can't be done because our sentencing scheme and incarceration scheme is so volatile and so confused and so complex that nobody ever knows when you're ever going to get out. That's his position.
I heard that, but I can't agree that that's the case because DOC knows how much gain time. I mean, DOC certainly knows the maximum amount of gain time somebody can get, so they can calculate their earliest possible release date. So I don't see that as a valid excuse.
So you see this as a DOC as the agency that's supposed to be doing these things, simply not carrying out its statutory obligations?
Well, but it keeps going down the line. DOC sends the files a year and a half ahead of time.
Was November the 16th, 2007, was when this case was sent to the disciplinary team, correct? And that was not a year and a half before his scheduled release date at that time?
Correct.
How much time was that?
Well, that's uncertain, but it's at least only a month and a couple of weeks, a year and a couple of weeks before the earliest release date we know of.
And what was the earliest release date?
It was December 1st, I believe. One of the expert reports, one of the experts from DCF said in his report that he was due to be released December 1st, 2008. The other expert said November 24th or something like that, 2008. But what I wanted to get to is that DOC sent the files, but DCF did not look at the files until May 2008. And then DCF made their referral July 9th, 2008.
But we do, just going back to the statutory scheme, and I think what Justice Lewis says I join in, which is the way the statutory scheme should work while the incarcerated prison sentence, because otherwise we have the issue of being held on a civilly, and so but on the other hand, our opinion in good and the statutory scheme itself contemplates that there will be continuances past the they're just supposed to be tried within 30 days, but that there could be a one-time continuance up to another 120 days, which would be 4 months. So I'm having trouble saying, yes, the statutory scheme contemplates that somebody would remain incarcerated, but also we actually admitted, or not, it's stated in good, that there's two different burdens, one if the defendant's incarcerated and the other if the defendant his sentence has been expired. So how do you resolve that? It's not, that is, there's not an immediate right to release under the statute just because your prison sentence has expired.
No, because at that point, the trial court presumably would have found probable cause and ordered the
And then
person detained.
your right to have an adversarial probable cause hearing to further show that this is not just, pro forma. There is really good reason to believe that this defendant will be found to be a sexually violent predator.
Right. But the 30-day limit for the trial, this court and other courts, I believe the second DCA have said, is the only thing in the statute that protects the individual's liberty interest when his
But in those other
sentence has
cases, in
expired.
fairness, the state, before, they hadn't even moved for continuance. I mean, there wasn't an issue about trying to even comply with the statute.
Right.
Here, they did. And the way to challenge whether the continuance was in my view, intrusion on his liberty interest, pretrial liberty interest, would be to seek relief pretrial.
But there are no rules.
Well, but
And
doesn't the adversarial probable cause termination also constitute a protection of the liberty?
it does, but the thing to remember about that is that once the judge again finds probable cause, the 30-day clock starts again. So in this case, the court granted the state's continuance, and in that order, the court set the trial for February 2nd, 2009. The court granted 120 days. The court at that hearing said that if the defense wanted an adversarial probable cause hearing, it would be the next week on the October 20th. So even if that hearing had been held, the 30-day clock would have started once again on that day, and still the trial would have been held beyond the 30 days.
But so, and maybe I asked you this, and I see your time's up, but just tell me, please, under the statutory scheme, what is the purpose of the adversarial probable cause hearing, if not to protect the defendant from being held unnecessarily by the state?
That is the purpose of it.
So when the defendant doesn't avail himself of that, shouldn't that bear on the whole issue of whether the defendant has been substantially prejudiced?
I don't think so. In this case, the defendant asked for the adversarial hearing. We don't know why it wasn't held. I don't know how many
the trial judge did in fact set it for the 20th, and we don't know why it wasn't held on the 20th.
I don't know if it's formally set. I don't know if there was like a notice of hearing. She said at the hearing that she would be, that's when it would be.
At the hearing on the 13th,
Correct.
she actually said you can have a hearing on the 20th.
Correct. I would ask the court to quash the first DCA's decision. Thank you very much.
All right, we thank both.
And what would that remedy be? Quash it and do what?
Quash
With
it,
prejudice, without prejudice?
order Mr. Boatman's release, and order dismissal of the state's petition without prejudice.
And again, your position there would be if it's without prejudice, your further argument is he wouldn't be able to be tried unless he is reincarcerated.
Correct.
All right, we thank you both for your arguments. That concludes today's docket.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.